Mr. Smith.
Morning.
Um,
Morning to the court.
did we reach out to Mr.
I did, I have not heard back from Mr.
So these are only on the new cases, is that correct? The 26 CR 2435?
Yes.
Okay.
That was his first appearance, it's just to set, today's just to set prelims.
Give me a moment just to look at your case.
Yes, ma'am. Take your time.
So we will schedule you for a preliminary hearing.
It was supposed to be today.
Sorry?
I was told in court just the other day that prelim would be today.
No, it was set for a preliminary. It was to set it for a preliminary hearing. The preliminary hearing is not today.
Today's the 10th?
Yes.
Okay. Yeah, the judge had said that the prelim would be set for today. That's why I'm here.
So, Your Honor, the note from BDA Finkelstein does say to set preliminary hearing. So
Yes.
this wouldn't be the setting.
The information from the minute order from Judge Brady was that this case was to be sent to Division 12 for an Arguello advisement. So that's your right to represent yourself. We'll do that in a moment. And to request to set the preliminary hearing within 35 days. It was not set for a preliminary hearing today. We do not set our preliminary hearings at 8:30. We set them at 1:30 in the afternoon. So this was to advise you as to your right to represent yourself, which I will do in a moment, and to schedule to set the preliminary hearing at the next court date. So we're going to be setting for preliminary hearing today.
Okay. And that's clearly my misunderstanding.
But, it's confusing, so not a problem. So there's a couple of things I want to address with you. First is, I know you have been advised previously of your right to represent yourself, but in each case, I need to advise you as to that right, okay?
Yes, ma'am.
You understand that you have the right to be represented throughout these criminal proceedings, and if you could not afford an attorney and you qualify, one would be appointed to represent you, correct? You understand that?
I hear you.
Okay. The high charge is a class 4 felony. Because you were on bond,
And actually, because it's a per se COP per the statute, the sentencing range would be 5 to 16 years. That is not mandatory for this particular count. Because it is a COB per se, the bond status is not a relevant factor to the increase of any potential sentence for that. So
all right, thank you. So the high charge is the count 2 that carries with it a presumptive range of 5 to 16 years in the Department of Corrections. If sentenced to the Department of Corrections, it would carry with it a mandatory period of parole of 3 years. Do you have any legal training, Mr. Smith?
Well, before we begin, may I put something on the record? Okay, so I want the record to reflect that I'm appearing in a limited capacity for the sole purpose of this procedure. I hereby reserve all rights under the United States Constitution and the Colorado Constitution. I explicitly do not waive any rights of any kind, whether known or unknown. Furthermore, I have not consented to the jurisdiction of this court. I'm appearing under compulsion of process to ensure that my constitutional protection is against warrantless seizures and lack of due process or appeal.
Okay. Do you have any legal training? Let me ask you this. Do you have any formal legal training?
I think I may need to object. I don't understand any of this. Okay.
Okay.
However, I'm still trying to wrap my head around this whole thing. And so I want to just make clear I'm under duress and I am trying to put all this together.
All right.
Okay?
Well, so one of the things that I need to do, that I'm required to do by Colorado case law, is advise you as to your right to represent yourself. You do have that right to represent yourself.
Okay.
And, but I do want to have a better understanding as to your understanding of criminal procedures. So for example, somebody may be very familiar with the Constitution and the rights that you have under the Constitution.
Okay.
They may be less familiar with trial procedures and things that you need to do to represent yourself in a manner that gives you the best opportunity for your defense, understanding that you're presumed innocent until 12 people would make a determination that the prosecution has met their burden. So that's why I'm asking these questions. I'm not trying to necessarily get into your personal life or what your actual beliefs are. I'm just trying to find out where your education is in terms of, that's why I said, do you have any formal legal training?
Right.
Like,
And I guess where I'm at as far as this whole procedure is concerned, I understand your role in part, and me gaining better insight about my role in part. It's my understanding that there's some things that have to be proven on the record prior to being to proceed to any trial or anything. My understanding is that the DDA and the people have to prove jurisdiction before moving forward towards any trial. This is before any plea deals can be made or rendered as well.
so I did see the motions that you filed,
Okay,
and I can just kind of address those right now. We'll get back to the advisement.
sure.
So, quo warranto, that is basically establishing who has authority to bring these charges against you. Under Colorado Revised Statute 16-5-205 and Criminal Rule of Procedure 7, the district attorney has been authorized by the Constitution and ultimately the legislature to file these charges against you. Subject matter jurisdiction basically is Colorado Revised Statute 18-1-201. Basically, any crime that is alleged to have been committed in the state of Colorado grants the state of Colorado subject matter jurisdiction. Your presence in court confers personal jurisdiction. So the court is finding that it has jurisdiction over this case.
And you said my presence in court?
Yes,
Okay, which is only under duress.
I understand.
Right. So if we're basing it on, I'm assuming that these are prongs that constitute consent of jurisdiction. That last prong does I guess translate into consent jurisdiction by my appearance here.
Yes.
Okay. Well, I'm not.
But if you
getting
don't appear in court, then the court issues a warrant for you.
Court issues a warrant. So again, because even the name that you guys are charging in itself is hearsay.
Okay.
And it's speculation.
So we're going to have
So
to
I want
agree to disagree on this right now because the case law is pretty specific
Yes, ma'am.
that the arguments that you're making have not been accepted by the appellate courts. And I understand that you will,
What argument? I'm sorry.
that basically by that, possibly the court doesn't have jurisdiction over you or that.
I'm asking the court to prove that it has jurisdiction over me as a.
Well, a charge has been filed in the state of Colorado.
Okay.
At the early stages, we only have to determine that whether or not there's probable cause. All right. At the time of a trial, if you choose to go to trial, the prosecution would have to establish that this crime occurred in the state of Colorado. That's one of the elements as to each charge, that the defendant in the state of Colorado did X, Y, and Z. Then the jury would have to decide Yes, that the prosecution has met their burden of proof that this crime that is alleged to have occurred actually did occur in the state of Colorado. So that's when it gets proven. At this stage, we're just operating off of probable cause. We're not operating off of proof beyond a reasonable doubt. A jury would ultimately determine whether or not this crime that is alleged to have occurred in the state of Colorado.
Wouldn't there be a hearing prior to this trial to determine if this case
No,
would
that's
forward to a trial?
so,
If so, why didn't I have?
because if you're entitled to a preliminary hearing, again, at a preliminary hearing, the only thing that the court is determining is whether or not there's probable cause, not proof beyond a reasonable doubt. So when we go to a preliminary hearing,
So that's prima facie, is that correct?
I'm sorry,
That would be deemed prima facie?
deemed prima facie?
Yeah,
No, it's not prima facie. It's probable cause. All right. That a person of ordinary prudence and caution, reasonable belief that this crime occurred in the state of Colorado. They will have a witness, or they should have a witness. They may not. But if they have that witness will be able to testify to certain things. If they don't testify that the crime occurred in Colorado, then the court would not be able to find probable cause. If I can't find probable cause, then the charge is dismissed. But we don't
all
have
the
to.
way to the trial date to be able to distinguish the facts
Yes. For proof, for conviction.
for conviction.
Yeah.
Okay. So do you contend then the jurisdiction has been proven already?
What I am saying is that a judicial officer has already determined that there is probable cause. I'm not saying it's been proven beyond a reasonable doubt. You keep using the phrase proven. All I'm saying is that someone has made a determination that there is probable cause that a crime has occurred in Colorado.
Okay.
For it to be proven, we have to go to trial, and a jury has to make that decision.
Okay. I think we're speaking about two different things. My consent to the jurisdiction of this court, and you're speaking towards the case, whether or not the case can be heard in the state of Colorado. It sounds like we're talking about two different things. Or
Charges have been filed against you.
yes, ma'am.
Some judicial officer, other than myself, has made a determination that there is probable cause to go forward with those charges. At the preliminary hearing, I will again make a determination as to whether or not there's probable cause to go forward with the felony charges, not with the misdemeanors. If I determine that there's probable cause, then the matter is bound over and gets set for trial. If I don't determine that there's probable cause, then the charges get dismissed.
Okay.
Okay? You had also raised something about habeas corpus writ. That's not really applicable here because you are not currently being detained.
It was during my detainment that it was written and submitted.
Okay. And then you had also addressed something about requiring a verified complaint. The prosecution under Rule 3 doesn't have to file a verified complaint. It just has to be signed by the prosecutor. The only complaints that have to be verified are those where they are also requesting a warrant at the same time, because probable cause was found by a judicial officer in which a law enforcement officer swore to the facts as he or she was aware of them based upon that sworn affidavit. Then someone determined that there was probable cause. So getting back to the advisement that I have to give you, you never really answered the question for me as to whether or not you have any formal legal training.
Second.
How far have you gone in school?
Give me
Okay.
1 second, okay? Thank you.
Oh, sure.
So in regards to the those two writs, what was your decision on that?
I'm denying them. If you would like, and I will do it anyway. I'll just issue a kind of a formal order denying it, so you have further information as to what I'm relying upon to deny it.
Yeah, I'm going to request a written copy of the advisements and the formal charges.
You're requesting
They're
a what?
properly served with an actual notice required by due process to understand the specific scope of the state's allegations.
Sir, if you could let me finish doing what I'm doing.
Yes, ma'am. Yes, ma'am.
Yeah, and then we can finish this so I don't lose my spot, and then you can make any further.
Understood.
Yeah.
Understood.
How far have you gone in school?
I have so many questions. Can you proceed without me answering?
Not really. And the reason being is I need to know if you representing yourself is presenting a great detriment to your defense. And this isn't under oath or anything. I'm just trying to make sure that you are fully understanding the consequences of you choosing to represent yourself as opposed to having an attorney represent you. Some of the arguments that you have raised either in your motions or in court, and I don't say argument as meaning you're arguing with me, just your positions. I'll say some of your positions have been raised by other individuals before, and generally similar arguments that have been raised have not been adopted by the appellate courts here. And so I appreciate your positions as to whether or not you think the court has jurisdiction to go forward with these hearings. But I will tell you, I've researched these issues before, and generally they have not been, your positions have not been adopted by the courts. And when I say the courts, I mean the appellate courts. And so my concern is for you that you may be relying on things on the internet or other things that people have told you that have not been accepted by the courts, and that may work to your detriment.
What can you tell me what things those are?
Well, if you're talking about, I haven't consented to jurisdiction, you have been charged with a crime in the state of Colorado. We're going to go forward with that until either if the district attorney chooses to dismiss a case, or we take the matter to trial, or you accept a plea. So for you continuing to say, well, I'm raising jurisdiction, I don't believe that I've consented to jurisdiction, and I'm not sure the state has jurisdiction. I'm not sure that the district attorney has authority to file these charges against me. Those are things that have generally been raised by individuals other than yourself that have not been adopted by the Court of Appeals. And so what I'm really just trying to make sure that you understand that representing yourself in this case can put you at risk of liberty, if I'm being perfectly honest. By you not adequately representing yourself, it could be that a jury may find that you are guilty. And then if you are guilty, as we talked about before, there's a possibility of a lengthy prison sentence. And so I want to make sure that you fully understand, by not relying on an attorney to represent you and simply relying on something that you may have found on the internet, I believe you're putting yourself at risk.
Thank you.
So I need to go forward with this. If you don't want to answer the questions, that's fine. I'm just going to go ahead and advise you as to what they are. You have not indicated that you have any legal training. You have not indicated to me that how far you have gone in school. Are you under the influence of anything, any drug, medication, alcohol, anything that's affecting your understanding as to what's going forward today?
No, ma'am.
Okay. Do you want to consult? I have currently 4 public defenders in my courtroom. Do you want to consult with any of them before you make a decision to waive counsel and represent yourself?
Okay. I do want to go put on the record. I'm not an attorney. I'm only exercising my constitutional rights.
And so this is my thing. I want to make sure that your rights are exercised appropriately. And let's say we were in a trial today. If you were having to constantly look at your phone to make sure that you're asking the right questions, or objecting to evidence that the prosecution may be trying to introduce, I don't think that's going to be to your benefit at a trial in front of a bunch of jurors, right? And I'm not even going to allow you to, well, that's not true. So you say you're exercising your constitutional rights. These four people here are very good attorneys.
Okay.
And they understand the Constitution, and they understand the rules of procedure, and they understand the statutes, and they understand what you could possibly be facing by if you are
I'm aware of the
convicted.
penalties. It's just a trust factor.
Okay.
This court is foreign to me. I have no relationship. I have no knowing or understanding of anyone here. And so I'm doing my due diligence to gain the best knowledge in order to combat this scenario. And so because of my lack of faith and trust in the judicial system based on my experience, which has been my own personal experience, what's been in the news and so on and so forth, I'm not altogether trusting of the public defender's office with my scenario. And so
And I'm not meaning to, you and I are in different situations, right?
we
And
are
so,
totally different positions.
and so your lack of faith and trust in the judicial system, that may, I'm going to say that based upon you're telling me your experience, you don't have trust in it. That's fine.
I'm just concerned about the lack of due process and the
Again,
inaccuracies in the state's record against me.
okay. We're going to go forward. My assumption is then you do not want to consult with any of these public defenders before you make your decision to waive counsel. Is that correct?
I'm sorry, say that again.
You do not want to consult with any of the four attorneys who are from the public defender's office before you make your decision to waive counsel.
Correct. Let's move
Okay.
forward.
Okay. This might be kind of a redundant question, but you do understand that criminal law, complicated area, having an attorney trained in this field could be of great help in helping you prepare and represent yourself in the defense of this case. So,
I had advisory counsel who is not present.
well, he hasn't, because he wasn't aware, he wasn't advisory counsel in these cases today, and because this got set so quickly from Division 20. But I will tell you, if we go to trial, he cannot ask questions for you. He cannot pick the jury for you. Those are all things, he can make suggestions, he can give you advice, right?
Right.
But
That's what,
Okay.
that's what I chose to have was
Okay.
be able to ask questions, someone I can ask questions.
You understand that as we go to trial, you have the right to remain silent, but anything you say can be used against you.
I did hear what you said.
Okay. We will go ahead and appoint Mr. Allen in these cases. As you've said, you've previously requested advisory counsel. I'm going to just remind you again that by representing yourself, you take a great risk of not properly presenting your defense to a jury. You have the right to confront any witness who testifies against you and cross-examine them You have the right to compel the testimony of any witness that you would like to have testify on your behalf. At this point in time, I'm giving you the right to represent yourself. I will go ahead and appoint Mr. Allen as advisory counsel. We have set the matter for a preliminary hearing. At that point in time, the court, after hearing testimony, will determine whether or not there is probable cause to bind the charges over and set this matter for trial. All right. Thank you, Mr. Smith.
Your Honor, I just had a few things really quick to address. First, regarding the defendant's request for a copy of any advisements and formal charges. He did get a copy of the complaint information on the last court date, to my knowledge. If the court is amenable to providing him with any sort of written copy of the Arguello advisements, we wouldn't have an objection to it. I would note that previously Mr. Smith also has been advised regarding the Arguello advisements and the other case that he currently has open. And the people would just ask that the court incorporate by reference in its finding regarding representing himself today the previous advisements that were provided to Mr. Smith.
I haven't looked at those. I haven't previously advised him.
When he began representing himself in the other case, Your Honor, I believe the court did give him an Arguello advisement.
I did not give him a Arguello advisement. I think that happened in DST. But I will go ahead and print out the Arguello advisement. I just printed it to the.
Actually, Your Honor, you are correct. I believe it was on March 9th, 2026. I think Magistrate Percio did provide the Arguello advisement.
Right. So I'm not going to adopt what she did, but I will note for the record that I advised him today and provide him with a copy. It's a generalized copy of the advisement. It doesn't specifically talk about the possible penalties that could be imposed in this case.
And Your Honor, if the court could also, as part of printing that off, just save a copy of what's being provided for Mr. Smith and then upload it to the Register of Actions by means of the clerk.
Sure. But again, that is not the specific advisement that I gave. It is only the generalized advisement because it does not include the possible penalties that he was advised of today. That will be for purposes of the record, which is being maintained by the FTR at this point in time. No,
You said that was an Archwell advisement?
excuse me?
Archwell advisement?
So the Arguello advisement is what it's ARGUELLO. That is the advisement regarding the right to represent yourself.
Got it. I got it right here. Thank you. All right.
All right. Well,
Your Honor, regarding the preliminary hearing, since he's out of custody, I believe that the only charge that is eligible for a preliminary hearing is count 2, and that's by virtue of the fact that it is deemed to be a crime of violence. So count 2 would be the prelim eligible count, and the people will be prepared to proceed on that on the next court date. If for some reason, and I'm just saying this for Mr. Smith's benefit, if for some reason there are any witness availability issues that people do need to raise, that's something that we would make the court and Mr. Smith aware of. I do know that we have 35 days following the filing of charges to providing him a preliminary hearing, unless there's good cause shown for continuing beyond that time frame. I would also encourage Mr. Smith to reach out to the DA's office as he did previously in the other case in order to obtain discovery. We're happy to provide that. Mr. Smith, I know you have my email and contact information. If you need to reach me and you have any questions about the discovery process, please feel free to give me an email. I endeavor to be responsive.
I sure will. In lieu of this, what transpired, we had corresponded right before that happened. So I'm clearly out and I'll follow back up with you.
Very good. And I appreciate our communication, sir.
I do too as well.
all right. Thank you, sir.
You too. Take care, Mr. Smith.
Still have any additional motions, Mr. Bullock?
Judge, I asked the court to observe that we have a scheduling conflict. There are 2 jury trials currently scheduled for this division on July 21st. There's the Miss Martinez's matter, as well as Miss Troutman's. The speedy trial in this case does not run until August 18th. It would be my request that we schedule the matter, reschedule the trial to time within that speedy trial time.
What's your position with respect to that request, Ms. Troutman?
Well, the position with respect to that particular request,
Yes.
rescheduling the jury trial,
Yes.
I can, I don't have a problem with rescheduling it out, as long as it doesn't conflict with my schedule.
Okay.
But there's also some elements, I think, that are missing from the case. There was no affidavit from a known victim with injury in fact.
All right. So what I'm going to allow you to do, I'm dealing with the people's issues, and then I'll let you state your issues as well. Okay.
Sure.
So why don't we see if it is possible to reschedule? Are they both in Benton County? Is that correct?
Yes, both are in Benton County.
Why did you think that? As far as you know, is the Martinez case going, Mr. Bullock?
Judge, we were ready for jury selections last time. I've heard no communication from Mr. Gutierrez.
All right. Is this a 3-day trial? And let me look at the felony complaint. Four counts, all occurring on the same date. A number of witnesses, I imagine a number of those witnesses are Department of Corrections inmates who are not going to be called. Is that correct?
That's correct, Judge. I would anticipate that 5 witnesses. I think we could do it with the trial within 2 days.
We'll look for 2 days before August. What was the speedy, Mr. Bullock?
August 21st. Or no, I'm sorry, August 18th.
We have your case conflicting with another case. That case comes on at 1:30 today.
I traveled to be here today, so my intentions were to travel.
Your intentions are what?
Were to travel back. It already takes up a very large portion of my day.
Okay.
Wednesday through Friday is kind of business days.
Your busier days.
Okay, so that's why Monday, Tuesday, I could make a Wednesday work.
But a Thursday, Friday is particularly difficult for you. The other option we have, it would be up to you, but if with your consent and advisement, I would advise you regarding this matter, but we could continue the matter in order to try to find a Monday or a Tuesday past the speedy trial deadline.
And I would need to waive my speedy trial rights.
Correct.
I guess my hands are tied in the matter. I won't be waiving any of my rights voluntarily.
Okay. Do you have motions that you would like heard in this case?
Yes, I need to make the record. The record is that I previously submitted the tender of special deposit, but it also included all the oaths of offices. So I accept all your oaths of office and I bind you to them. The other matter I would like to bring attention to is the lack of improper service and the waiver of service that was sent to me by a Cheryl Martin in response to that. The other thing was that the victim, in fact, is not present with injury in fact. I don't know if there's a part in that discovery where it is. I didn't see it. And the other thing was with the jurisdictional elements, the constitutional requirements. Knowing the nature and the cause of the action is my Sixth Amendment protected right. The court mentioned that they believe that they have jurisdiction, subject matter jurisdiction, but it wasn't actually proven for the record. So I asked for the delegation of authority as well, so that I may proceed knowingly.
I'm sorry, I don't understand what you're saying. And you didn't file any written motion, so I can't even really look at those. But go ahead. Tell me what you mean.
Is your delegation of authority, Judge McDonough?
Like delegation of what authority?
Is what part of the Constitution are you operating out of? What is your delegation of authority?
I'm not going to answer questions for you on the record, obviously, but the court is operating pursuant to the laws, which means the statutes and the Constitution of the state of Colorado.
And the Supreme Constitution, which would be the national constitution as well, because that's the supremacy.
Only to the extent that the Constitution leaves matters up to the state to determine the manner in which they desire to exercise jurisdiction and run courts in each of the 50 states.
And it is solely judicially, correct?
No, it's legislatively and constitutionally.
Okay, then I think
I don't know what you mean by solely judicially. I'm sorry.
Article 3, Section 2 of the Constitution.
Of the United States Constitution.
Yes, which
that defines federal courts.
sure, and state courts have to, if there's any conflict between that clause and state constitution, then the state constitution would have to give way to the federal.
Correct.
Well, thank you for saying it was legislative. I think there's a false presumption of law that I have not been able to rebut. Just to, my submitting to the court, my notice and declaration of beneficial standing as one of the people, not to be confused with any Adamsonians or legal fictions.
Mr. Bullock, any response?
Yes, Judge. The statements and arguments made by Ms. Troutman aren't recognizable under the state law of Colorado or the United States. I understand that she may have questions, but the oath that we took is to follow the laws of the state of Colorado, and there's been no alleged violation of the statutory authority or the constitutional court's authority without any specificity alleging some kind of violation under the provisions of the law that provide adequate notice. We really aren't in a position to argue Ms. Troutman's claims. I can tell the court that I would address the two issues of the waiver of service. Ms. Troutman has waived the jurisdiction of this court by her appearance. The victim in the fact is the people of the state of Colorado. So I appreciate the issues she brings up, but I stand by my statement that they're not based under the applicable statutory or constitutional authority.
Thank you, Ms. Troutman.
There has been no known waiver of service because I have shown up here every single time out of honor and in good faith to settle and address the matter. There is no waiver of a rights or waiver to prove jurisdiction for the record. Also, as me being one of the people, I am afforded the right of judicial process. So I'm not sure what not understood about that. that's where the nature and the cause of the action is so important. And cause of action statutorily, but the nature is still has not been revealed. These crimes seem commercial in nature.
Bullock, was the summons served, or are you relying on the fact that Ms. Troutman has come to court and waived any prospective service? Does your file reflect that there was any service made?
Our basis on her is on her voluntary appearance in court. Apparently it was sent to her, but it was not actually served.
All right, last chance, Ms. Troutman. It's your motion, so I'm giving you the chance to go last. Is there anything else you want to say?
That I object to them solely basing their service off of my appearance made out of good faith and in honor.
All right, thank you. The court is going to deem that Ms. Troutman has waived any jurisdictional defects to personal jurisdiction based on her voluntary appearance in court.
Voluntarily, but under duress and threat and coercion of bodily harm via the warrant that would be issued and resulting assault and battery and kidnapping that would ensue should I not appear.
The court notes that Ms. Troutman has appeared on October 25th, on December 1st, on January 5th, on January 21st, on February 2nd, on February 18th, and then on today's date, Troutman has submitted an application for a public defender in this case. The court deems that it has personal jurisdiction over Ms. Troutman sufficient for it to proceed on the matter.
And by what deem is that? Because
By what deem?
yeah, like what do you deem the court's personal jurisdiction on?
Your voluntary appearance in this court on numerous occasions.
My voluntary appearance that isn't voluntary? That it's under threat, duress, and coercion?
There was nothing compelling you to appear. You've appeared on numerous occasions. Really, the court established jurisdiction at your first appearance.
I have prima facie evidence from text messages received saying that should I not appear, it may result in a warrant, which false imprisonment is equivalent to assault and battery and kidnapping.
The court will allow you to file those and to make a record regarding that matter. The court deems it has jurisdiction. You have other motions that you have filed in this case.
The beneficial ownership is third-party intervener to the property in the case.
I don't know what that means. I know that the court had prepared an order related to the jury trial that's scheduled in this matter. That jury trial required you to file any written motions by a date certain. You were given until the close of April 1, 2026. You file motions in this matter. No motions have been filed. The court doesn't understand your oral motion, doesn't believe it's legally sufficient.
Then
Mr. Bullock, do you want to be heard on that matter?
Your Honor, again, I do not have sufficient notice in which to respond to any motions that Ms. Troutman's arguing. I can tell the court that her statements are not recognized as any particular defense recognized by Colorado law. Till I have legal analysis as to what her claim is, I'm really in no position to go forward.
Court is going to deny the oral motion on the record. I take it as a motion to dismiss. Are really based on subject matter jurisdiction, indicating that the matter is primarily commercial and not criminal in nature. However, the people have initiated this by the filing of a summons and complaint. That complaint does set forth several charges against Ms. Troutman under the criminal laws of the state of Colorado, and that's how the court will proceed in this matter. Are there additional matters that you want to bring before the court's attention?
For the record, I would like to give notice that there are rights, titles, and security interests that are obviously uncognizant to this court.
So the court will allow the record to stand in the terms of Ms. Troutman's position that there are right, titles, and other interests not subject to the cognition of this court. The court is going to include the motions hearing set for today. The matter was also set for pretrial readiness conference. Mr. Bullock, are the people prepared?
We are for both dates.
Have you had contact with any victims or witnesses in this case?
Your Honor, all of the witnesses are correctional officers or forensic scientists with the Colorado Bureau of Investigation. All of our witnesses for the trial are under subpoena. They're prepared to proceed.
Thank you. Ms. Troutman, are you prepared to proceed to trial on this matter? You have a copy of the court's order setting this matter for jury trial?
I do. I am getting the copy of the file from the clerk.
You're going to want to be aware of that particular order as it will control the proceedings.
In the jury selection?
The jury selection as the matter goes to trial, okay? There's some matters of jury selection that you'll discuss with the trial judge on the morning of trial.
Who will be the trial judge?
The trial judge will be the judge who's sworn in to replace me.
Moving forward under threat, duress, coercion, and the extreme inequities of this case.
Right. The court has previously advised you extensively related to your right to have counsel. Do you recall that advisement?
I recall that it is my right to have counsel. It is also financially unattainable. So it's kind of like a rock in a hard place, inequitable.
I understand that you've made application for court-appointed counsel, and I appreciate that. The court determined based on your income that you are not eligible for counsel. That applies also to advisory counsel, which we discussed as well. So I understand your position, and
I have a right to also represent myself, but if the court is not operating under the common law and it's purely legislative, then how is that constitutionally valid again?
I don't understand the question. I'm sorry, Ms. Trump.
Okay.
Yeah, jury selection. So what will happen is you'll come in, you'll have a conference with the judge at 8:00. You'll be back in front, seated where you are now at 8:30. At 8:30, the court will start the process of, or about, depending on how long it takes to check in the jury, the court will begin the process of selecting a jury.
And where are the rules regarding this jury selection?
Colorado Rules of Criminal Procedure and the statutes of the state of Colorado. Both court rules and statutes govern jury selection process.
Okay. Tentatively, trial will happen on August, should it not be moved to federal court before then. This is my notice to seek redress and continue the matter for constitutional review.
Anything else from your standpoint today, Ms. Troutman?
All rights are reserved, cognizable and unrecognizable to this court.
Thank you. Court will be in recess on this matter.
These cases are another reminder that confidence without legal understanding can quickly turn into costly mistakes. The courtroom runs on facts, evidence, and the law, not internet theories or personal beliefs. And today's hearings made that crystal clear. If you enjoyed this breakdown, be sure to like the video and share it with your friends, family, or anyone who enjoys real courtroom cases and legal commentary. And if you haven't already, subscribe to the channel and turn on notifications so you never miss our latest courtroom breakdowns and case updates. We appreciate every one of you for being part of the community. Thanks for watching, and remember, the next courtroom surprise is always just one case away.